Hello, my name is William Dale. I'm an attorney with the law firm of McChesney Dale in Bowie, Maryland. Today I would like to talk about an issue that comes up frequently with our estate planning clients, and that is whether or not the client should have a revocable trust. A revocable trust can be a very important part of an individual's estate planning and may be an appropriate document to accomplish the client's objective. Some attorneys recommend revocable trust agreements as a necessary part of estate planning and recommend that it be used in every circumstance. I don't subscribe to that view. I think revocable trust agreements can be very helpful in certain circumstances, but in other circumstances are not really necessary and perhaps cause a little bit more aggravation than they accomplish in either financial savings or in assisting the client in accomplishing their planning objectives. What I'd like to do is share with you some of my thoughts on that issue so that you can make your decision, because it is your decision as to whether or not you want to establish a revocable trust and use that as part of your estate planning documentation. I can give you advice, but it's your call. What is a revocable trust? A revocable trust is a trust that is established during someone's life. It is usually established with the same individual acting as both the grantor, which is the person who puts the assets into the trust, and as the trustee. That is the person that invests the assets, makes sure that they are protected, and holds on to them for the benefit of the beneficiaries of the trust. And as I said, usually with a revocable trust, that is the same person acting as grantor and trustee. A revocable trust is, by its very terminology, a document that can be revoked at any time by the person who created it, or it can be amended at any time to change the beneficiaries, add beneficiaries, change some of the rules that are set up in the trust document. The trust document gives you the opportunity to write the rules as to how the trust is to be administered during your lifetime, and perhaps more importantly, after your death. It allows you to determine who is to receive the trust assets, whether it's to be held for the benefit of your spouse or for your children, and ultimately how it's to be distributed. Now, there are many kinds of trusts, and a revocable trust is just one of them. There are trusts that are used for income tax purposes, charitable trusts that allow you to use a trust vehicle to make contributions to charities while retaining some income stream from the assets. Or there are irrevocable trusts that may be used to avoid or limit the amount of taxes, federal estate taxes, that may be paid. Today we're just talking about a revocable living trust that is established by the grantor, the person doing the estate planning, during their lifetime. What I'd like to talk about first is what would happen if you don't have a revocable trust and then you die. Your assets would be distributed in accordance with a number of different rules. If you have property that's held jointly with right of survivorship with another person, or as tenants by the entireties with your spouse, those assets belong to the surviving joint owner or tenant by the entirety, your spouse, without any court order or any procedure that has to go into effect. It automatically is owned by the survivor. If you have assets that are distributed because you have designated a beneficiary, such as an IRA or a 401k plan or pension plan, or you've designated a beneficiary on life insurance, or you have a payable on death account that is distributed to a particular individual, your assets pass based upon the beneficiary designation, not upon any separate documentation like your will or a trust agreement or any other documentation. If you have individually owned property that is not held with someone else's joint tenants, that property would pass in accordance with your last will and testament. And the process that is used to make sure that the property passes as you wish is called probate. It's a process that is administered by a court or a register of wills to ensure that the wishes of the person who died and who has written the last will and testament are properly observed. So if you don't have a trust agreement, these other rules would determine how your assets are to be distributed, and they will accomplish your ultimate objectives, although there is some cost involved in going through the probate process. Now, if you have a trust agreement, a written trust agreement, and you properly place all of your assets into the trust, and when I say all of your assets, there may be some assets, like pension plans or IRAs, that really should not be distributed into the trust, but rather should pass outside the terms of the trust. But with respect to most of your other property, you need to properly place it into the trust so that your bank or your broker or the land records all show that the trustee holds title to the property and is administering it in accordance with the written trust agreement that you have signed. Upon your death, if you have a revocable trust agreement that has been properly funded, the trust seeks to be revocable because you no longer are able to revoke or amend it. It becomes an irrevocable trust, and the assets are to be administered in accordance with the rules that you have set forth in writing in that trust agreement. The person that you have designated as your alternate trustee or successor trustee would then have the authority to take hold of the assets and administer them in accordance with the terms of the written trust agreement. One benefit of having a trust that is properly funded prior to your death is that you are able to avoid probate. Again, probate is a court-supervised process, and if you have properly set up your trust agreement, the trust determines how your assets are being distributed, and there is no court supervision of how the trustee is handling those assets. While there are certain costs associated with probate, they're not huge. Probate does not require taxes to be paid any differently than if your assets are set up through a trust agreement. So one of the benefits of having a trust agreement is to avoid probate. Second benefit, which is closely related to that, is that your assets are handled in a private manner. Court records are public records, and the probate process requires filings that determine what your assets are and how they're to be distributed, and that information becomes public information. So if you really want to avoid having your assets and the manner in which they're distributed to be a matter of public record, then a trust agreement is a good tool to avoid the probate process and public disclosure of the information that would be contained there. But when clients ask me if they should have a trust agreement, I generally tell them that in certain circumstances a trust is the appropriate way to go. In other circumstances, it may be more of a hassle to them than it really is worth. And I base a lot of my recommendations on the age of the client. As clients get older, as they retire, their assets will tend to be more static. They will have less likelihood that they're going to be buying and selling vacation homes or opening and closing brokerage accounts or moving money from bank to bank, and they're much more likely to have a set group of assets. And that's important because in order to properly implement a trust agreement, you have to title your assets in the name of the trust, as William Dale as trustee of the William Dale Trust. If you don't title those assets, then they're going to bypass the trust and they will go through probate, so that there will be the public disclosure of those assets. But the point here is that as people get older, their ownership of assets is less likely to change considerably over time, and there is less of a need to have to worry about making sure that every time they purchase something of considerable value or make an investment, that the investment is properly titled in the name of the trust. Younger people, particularly families with kids, they may change jobs many times over the next 15, 20, 40 years. They may move, they may buy and sell houses, vacation homes, set up brokerage accounts, buy life insurance, change life insurance, make different investments, partnerships, or set up corporations to accomplish certain business purposes. In order to properly make use of the trust, every time any of those transactions is undertaken, the person has to make sure that it is properly set up in the name of the trust, that anyone dealing with the person understands why it's being set up in the trust, and sometimes that's a little bit difficult to explain. Have to make sure that the bank accounts are set up in the trustee's name instead of their own individual name. And when a client is younger and has young children and more fluid investments, their need to worry about whether or not probate is an important issue in their life is still probably years away. It's not something that is an issue that will need to be confronted in the near future. So often young clients will decide not to use a trust agreement because it simply is more difficult to make sure that they're complying in full with all the requirements of the trust during their lifetime, where they really don't expect to have to worry about probate for many years in the future. Now, one important thing that you need to understand about a revocable trust agreement is that it uses your Social Security number. It's not a separate taxpayer, and any investments in a trust that creates income, dividends, interest, capital gains, that's all reported on your own individual tax return. So it is not something that during your lifetime requires filing additional tax returns. Once the trust becomes irrevocable, once you die and it ceases to be you for purposes of federal and state income tax, then it needs to get a separate employer identification number, which is the tax ID applicable to a trust. And from that point forward, fiduciary tax returns would be due. Now, a trust can be set up in your last will and testament to accomplish some of the same objectives that a revocable living trust is set up to accomplish. For example, if you have minor children and you want to make sure that they are taken care of, but you can't give them assets directly, the minor children can be the beneficiaries of either a revocable trust after your death, or of a testamentary trust, which is set up by your last will and testament. So in order to set up a trust to protect your children or grandchildren or brothers and sisters, if you have them as beneficiaries, you don't need to set up a revocable trust. You can accomplish that through your last will and testament. But if you do it that way, your assets would go through probate in order to ultimately find their way into the trust as directed by your last will and testament. I think it's important for you to talk to your attorney, talk to your accountant, talk to any other advisors about whether or not a revocable trust is appropriate for your circumstance. It is a useful estate planning tool, but whether or not you need to establish one now is a personal decision that you need to make based upon a lot of facts and circumstances, many of which I've discussed here today. My general recommendation to clients, particularly younger clients, is that there may come a time in your life when a revocable living trust is an appropriate estate planning vehicle for you. Again, talk to your attorney and other advisors to see whether that is right for you. Thank you.